Next case on the docket is NORA French versus Ruth Ross.
Good looking tie you got there. Well,
Thank you. Thank you. I figured it was the holiday season. We should celebrate it.
How much time do you want to try to save for?
5 minutes, Your Honor.
Okay, so just so we're clear, it's going to count down from 20 minutes to 0, and it's up to you to keep track of your time. The light will turn yellow when you're at 5 minutes into your rebuttal time.
Very good.
Okay.
May it please the court, my name is Bob Wilkins. I'm here representing Nora French in two capacities. One is the personal representative of her deceased husband, and the other in her individual capacity. The main issue before this court today is one that has never been squarely decided by the courts in Florida, and it would seem to be a clear and distinct policy decision for this court to decide. The question is, should a beneficiary be rewarded for willful ignorance or neglect of a trust when they themselves were equally and jointly responsible for the administration of the trust? Stated another way, can a trustee who's also a beneficiary completely abdicate and abandon their responsibilities as a trustee without any consequences whatsoever? That's exactly what happened in this case. As a matter of public policy, a trustee has duties. It has certain legal duties that are, in fact, some of the strongest known under the law. And a trustee who accepts that responsibility needs to discharge those responsibilities. If they do not discharge those
Public policy question, why shouldn't it be decided based on the nature of human relationships and how people work? I mean, in a case like this where a child who is probably going to inherit some money is placed as a co-trustee with her father, which seems like a normal thing to do. I mean, it seems like the father who has use of the funds, the interest, and is, during the interim, any child's gonna just say, whatever you do, Dad, that's fine. I mean, they're named as a trustee, I think, probably in recognition that when the father passes away, she needs to be there. But I mean, really, I doubt that in any case you're going to have a child that's calling Dad and saying, okay, I need to get this county, I need to do this. That's just not going to happen.
Well, as a practical matter, that's no defense to a discharge of.
You're saying there's this public policy question about how we should hold that child responsible under these under facts like this, and I'm saying the nature of the reality is I doubt there are many children out there that have a good relationship with their parent that are going to jump in there and do the kind of things that a trustee ought to do.
Well, first of all, number one, this is not a young child, okay? Miss Ross was a fairly substantial adult who was an editor, a science editor. She was very well educated. She was not, we're not implying that she was an 18-year-old child that was supposed to be co-trustee with her father. The second point to make is the reason back in the day when this type of trust was set up was that you didn't want the surviving spouse to be the sole trustee of the trust, because you ran the risk that the IRS would say that since they are the sole trustee, and they have the ability to manage and run the trust, they could drag it back in and be included in their taxable estate. That's the reason why these kinds of trusts are done. Since that time, the IRS has basically taken a different tact and said, as long as you have ascertainable standards, we can have a parent as the sole trustee. But I am not aware of a single case anywhere in any jurisdiction that said that you can abdicate your responsibilities as a trustee because you trust your parent. There is no such case. There shouldn't be any such case.
Well, should the public policy take into consideration at all the relative deficiencies of the trustee? I mean, between a trustee who robs an estate, or robs a trust, as opposed to somebody who was negligent and didn't catch it? Should they be considered in the same way, or should there be some consequences of the relativeness of the actions?
Well, there may be, and the Anton case kind of addressed that. This was, again, prior to the current trust code. The Anton case basically said that really doesn't matter. The relative responsibilities of each party don't matter, and if the trustee who was the one who committed the act gets sued, the innocent trustee is equally liable. Now, since that time, the statute has been amended, but that's not the statute we're under now. As a matter of public policy, I think the legislature probably has addressed that, but it was in response to that Anton case, and it's not the law that applies to us here today. The second thing that, if you look at, and the court asks about the family relationships, what the court said that excused this trustee from any responsibility, no reduction of her damages, absolutely no consequences whatsoever, were based on the following facts, none of which have anything to do with an excuse or defense for a breach of trust claim. Number one, she was the daughter of the trustee, and she trusted him. Again, there's no case that says you are absolved of responsibility just because you trust your dad. Number two, she lived in Virginia. He lived here. That's not a defense. She says that attorney Ken NORA didn't explain to her legal duties as trustee, so she really didn't know what she was supposed to do. Of course, Ken NORA didn't represent her, and she also agreed that she never consulted a lawyer on her own to determine if she had any other responsibilities.
Mr. Wilkins, this argument that you're making, this policy argument, ties back into the statute of limitations argument?
It does.
You're making.
It does.
Is that?
That's correct.
Broader.
It is, and that's my point.
I got you.
My point is taking that argument and sort of moving ahead. This argument would apply even if the statute of limitations doesn't apply. But we think here the statute of limitations is a complete defense to the action, that and latches.
Well, talk about the issue about the jury trial, because it seems to me that if you're right that you were entitled to a jury trial, it moots out all these arguments about what the court found and whether or not those were relevant factors, because you got to go do it all again with a jury, right?
Well, I think that's correct. I mean, our first position is that the court got it wrong, regardless of the jury trial issue. The court got it wrong, and based on the record that we've got, this should have been decided on summary judgment. And this should have been granted a directed verdict at the end of the trial.
Well, whether it should have been decided at a directed verdict would be mooted if you were right that you're entitled to a jury trial. Whether it should have been decided at summary judgment, that wouldn't be affected if A, you moved for summary judgment, and B, you appealed on the basis of it was error for the trial judge not to grant you a summary judgment.
And that's part of our argument in the brief. But to go to the jury trial issue, there is clear case law that says that if you are asking for damages for a breach of fiduciary duty claim against a trustee, that is an action for damages. It could be nothing else. It is not asking for an equitable lien. It is not asking for constructive trust. It's asking for, what they asked for in this case was a money damage judgment against the assets of the estate. Now, that's wrong in and of itself, because when you file a claim against an estate and the estate objects to your claim, you bring an independent action on the claim, and the point of that litigation is twofold. Number one, to establish the validity of the claim, and number two, to determine its priority. Once those two things are determined, then the claim is validated within the estate and it gets paid in accordance with the priorities of the trust code.
And does it get filed as a general civil action, or does it get filed somehow related to the...
It is a general civil action. It has nothing to do with probate. And in this case, it's curious, they captioned the case initially, in re the estate of Stanley Wilson. Well, it really had nothing to do with the estate of Stanley Wilson. That estate was in a separate file in the probate division. And then they go further to say that Ruth Ross petitioner versus Nora French as the personal representative individually. But the independent action itself, there's a case in this court, the Allen versus Dutton case, said that if you're litigating over the establishment of a claim against an estate, that entitles you to a jury trial. That's the Allen v. Dutton case that this court decided some years ago. So I think if we go back and have to try it as a jury trial, most of the issues are all going to be interrelated. The whole thing should be tried as a jury trial. So,
And tell me again how you distinguish NAE, the...
couple of reasons. Number one, the primary one is the beneficiaries of NAE weren't the trustees. That totally distinguishes NAE on all four corners.
NAE, I mean, it said generally litigation involving a family trust is an equitable action.
Well, I think some of the claims clearly were equitable, but some of them were legal. If the issue is related to the jury trial decision, some were equitable. If they didn't have those legal claims in there, we wouldn't have the right to jury trial. There's no question. But also think about this point as well. If you come to court asking for equitable relief, you have the right or you have the obligation to come in with clean hands and to basically say to the court, look, I'm innocent. My damages have been caused. I need to be given equitable relief from this court. For anybody in any equitable proceeding to come to court, they've got to basically come there with clean hands and with no basis for an estoppel against their claim. Here we've got an 8-year lag from the time the events occurred to the time this beneficiary came forward and said, look, I don't know where the money went, and I think my dad took it all. And as it turned out, it happened in 2002 and 2003, 7 to 8 years before she ever filed a claim.
This is relevant, but was there evidence that he intended to disinherit his daughter?
No, there was no. I can only speculate, and I think if you read between the record, he was not a bad guy. In fact, he was a pillar of the community. I think, frankly, he just didn't understand what he was supposed to do. When they initially funded this thing with these short-term T-bills, by definition, they're going to mature and get distributed out right away. They were distributed out to a joint account, and I guess he assumed, well, I guess that's what happens. That's as long as the trust runs.
I guess, I mean, it's maybe even irrelevant to the legal issues in the case, but I mean, it is sort of disturbing that the effect of your position is that this woman gets disinherited in favor of someone else. I mean, it just doesn't seem equitable at all.
The equities are who could have prevented this from happening. She could have. Had she discharged her duties as trustee, this would not have happened, or at least it would have been prevented or detected long before. How do we know, and we don't, how do we know that because of the increases, the only reason this trust was in effect was for state tax purposes? Let's be clear about that. That's what a credit shelter trust is.
I don't understand, I saw that in your brief. I don't understand the relevance of that. He's still bound by it. I mean,
he is, but my point is that if the reason for the existence of the trust went away, let's take an example. If this had been 2008 when his wife passed away.
Maybe they wouldn't have set the trust up, but they did set it up, and one of the things that they did in there because they felt like they had to, for whatever reason, was to, upon her death, the father couldn't take the money. So.
He had it set aside. Initially, he did. And he still had some assets in that trust at the time of his death. They claim no, but we've got documentation that shows that the trust was still in existence. He was still listing it on his Quicken reports.
If there was equitable claims and legal claims, and you're correct that there should have been a jury trial on the legal claims, but the trial judge found for the plaintiff on the equitable claims, why isn't that a harmless error?
Because I think you can't abrogate the right to a jury trial just because you've got equitable claims that could be decided by the judge. If you had a jury trial, generally what happens is you try the jury trial issues first, and then the court...
The trial judge doesn't have to, the trial judge is not required to be bound by the findings of the jury.
No, it is not. But the claims that would have been decided by the jury are really the principal claims in this case. A lot of the equitable...
trial judge isn't bound by that. The trial judge on the equitable claims could make entirely different and contradictory findings of fact.
He could, but that's theoretically that's potentially possible, but in my experience, I think you really tread on thin ice if you were to do that as a trial judge when you've got a jury that basically finds facts that really are dispositive as to the equitable claims as well. The question for the equitable claims is what would be the relief granted by the court. That's really the issue on the equitable claims. You know, can you basically impose a constructive trust? Can you cause an equitable lien to be attached to certain property? Those things I think the court can do that the jury can't do. And so that's why I think you find the facts in the jury trial, and then you would take those facts and determine the equitable remedies, if there are any, based on what the jury found. If the jury in this case was given the statute of limitations and given the instruction that says that the knowledge that a trustee has is imputed to them as a beneficiary, if that were a jury instruction, can we have any doubt that the jury's going to come back in favor of Ms. French? Of course they would. That's exactly what this case is all about. You can't bury your head in the sand and become an ostrich and then wait until your co-trustee, who might be able to explain what happened or why it happened, they die. That's the classic laches claim. And this was 8 years after the fact. And we have other activities that she had the statements. She herself produced 10 statements that she got from her father from 2003 to 2005. So even if we don't have the imputation of knowledge that we believe exists in this case under the Smathers case, she has actual knowledge. She got those statements and she produced them at trial. She had them. She may not have looked at them, but I don't think that's a defense to her claim as a beneficiary. And in those statements, you'll see very clearly what was in the shelter trust, very few assets. He specifically identified them. He wasn't hiding anything from her. Indeed, if you look at his statement of settling Stanley's affairs and what to do if I'm down for the count, those are all in evidence. When you look at the...
He could have got her written consent to transfer the assets and he would have been fine, right?
Of course. Of course.
Let me ask you about the tracing argument.
Yes.
On the equitable lien. What is the tracing requirement? Where does that come from? Is there case law that says you got to trace? And then what was the evidence in this case that either did or didn't trace anything into the accounts?
The tracing on the equitable lien is you have to put an equitable lien on certain property of the defendant. You've got to establish what property of the defendant you're placing that lien upon to make them the constructive trustee to be able to return the property to the rightful owner. Here, what he had were, and I don't know if you'd say it's the CDs that they tried to retitle, maybe. Was it the T-bills that went into the joint checking account that I guess he bought the CDs from? The tracing requirement, I think, would require her to have gone and found out, let's just start with the 4 CDs they were trying to reset into the trust, and who knows where those letters went. It's kind of odd to me that they were never delivered, even though he signed them, she signed them, and Ken Murrah doesn't know what happened to them. What you'll see is she needed to take those CDs that she claims were hers, she needs to roll forward and say, okay, these funds went to this new account when Washington Mutual folded, it went to this account.
And once it's in that account, if there's transactions in that account and other money comes in and other money goes out, does she lose it if she doesn't show that exact money stayed in that account, or does she get the benefit of whatever's in the account at the time he dies?
I think she would probably be able to get the benefit of the money that was in the account at the time she died, but...
Was there money in those accounts when he died?
No, none of, well, those CDs didn't exist at the time he died. The checking accounts that the T-bills were rolled into didn't exist at the time he died. So you've got this whole issue. The assumption of the trial court and the assumption of Ms. Ross's counsel is, well, she got everything, so clearly she got everything. But they ignore the fact that he could have spent it. He could have, in fact, he did. He bought a $160,000 non-refundable unit at Mayflower. So 160 of the 309, we've got documentation saying he went there.
If he bought a condo for $160,000 instead,
and she could trace that?
Have a claim for an equitable lien in the condo?
Yes.
Because the payment came out of that account?
Absolutely. I'd like to reserve at least the minute I've got. Thanks.
Your Honors, good morning. My name is Greg Wilson. This is Mr. Don Scarlett. We're attorneys for Ruth Ross, who is the daughter. She's a beneficiary and a co-trustee. Certainly heard all your questions. They were asked to the local judges a number of times in a number of different motions and motions for retrial. They've been argued before, during, and after the trial. If you'd like me to go through each one of those, I will, but I should point out...
Why wouldn't they be entitled to a jury trial if you made a claim for money damages and in fact ultimately got a money judgment, not just equitable remedies?
Well, that's an equitable remedy. You're asking two questions. First of all, you can ask for money damages, and I cited a case on it. And that doesn't mean it becomes a legal issue. It depends on what the facts of the case are.
Doesn't it depend on what the cause of action is? In this case, you had a cause of action for breach of fiduciary duty. Isn't a cause of action for breach of fiduciary duty normally a legal action that someone is entitled to a jury trial on?
Well, if you look at King Mountain versus Gunlich, which is cited at page 24 of my brief, it cites in there a fiduciary commits a breach of duty as fiduciary is guilty of tortious conduct, and the beneficiary can obtain redress either at law or in equity. And it doesn't make any difference if they just seek a mere label of damages as to whether it's law or equity. And Judge Perry ruled that the whole issue in this case was one of equity to replace the funds that in essence, to use the worst word you can attach to all this, that was stolen from the trust. It was commingled. And you were asking about tracing the funds. The funds went into this U.S. bonds. Our exhibit number 2 in the trial showed where the funds went from there. They went directly to the father. And from there was a commingling of the funds. Even NORA French admitted in the trial that there was a commingling of the funds. You can't do that. The relief is equitable. The statutes allow a judge in a breach of trust action, which is really what we had here, to find whatever remedy is appropriate. You can void the action or whatever transaction occurred. You can find, in fact, one thing says you can find any relief that is appropriate. And you can redistribute funds. In this case, Nora French, whether she was personal representative or whether she was an individual, was actually, in essence, a constructive trustee, or there was a lien on those assets that she got without paying for that were really assets that belonged to my client. And the law, there's a bunch of law I've cited in my brief that says if there's a commingling of funds and money is spent out of there, it's presumed that that's the personal individual's money, and whatever is left to pay off that which was taken or commingled or misappropriated, or whatever word you want to attach.
How do you respond to the case of the guardianship of Medley that was cited in the briefs? That was a case where the question was whether a ward in a guardianship had a constitutional right to a jury trial in a claim for breach of duty. The court held they had a right to jury trial on the claims for breaches of fiduciary duties, and it distinguished the King Mountain case that you made reference to, saying the cause of action in that case was distinguishable. A condo association sought to discharge secret profits. The court found that cause of action arising out of that particular fiduciary relationship was only cognizable in equity. But in the guardianship case, as a claim for breach of fiduciary duty, they were entitled to jury trial. Is that case distinguishable, or is it your position that case was wrongly decided?
I can't answer that. I would be giving you purely my opinion. All I can tell you is what the court ruled and what the court found and what I think is correct, and that is that what was being sought here was equitable relief. Of course, the court gave equitable relief, and the court had the authority to give.
Relief that was given in this case, did it include a money judgment?
It did.
Which could then be levied on like any other money judgment. It wasn't limited to some equitable lien remedy?
It was a money judgment. I didn't write the order, Your Honor.
There were assets in the estate, though, right?
There were $70,000 worth of assets in the estate. The rest of the money went to the new wife because she was a joint tenant after it was put in joint names. So,
He inherited the money from the decedent
as a matter of law, yes, because she was a joint tenant with it.
by operational law.
Right.
To get an equitable lien, do you have to be able to trace the funds into whatever you're trying to attach the equitable lien to?
There's a bunch of cases on that, and the cases say that you can trace the money, which we did, and the money went to the dad. We don't know where it went after the dad had it. We can't tell how he spent it, but we know he had a lot left over. We know he transferred around $900,000 to his new wife by joint tenancy. Plenty of money there to cover the approximate $400,000 that belonged to the trust. Also, I think what started out this argument today was that this was something that had never been decided before, whether a beneficiary could be rewarded when they sat and did nothing. That might have some bearing in the case if there was a third-party beneficiary bringing a lawsuit against the trustees, where my client could be jointly responsible. Of course, they've changed the statute now, but back at the time, jointly responsible for what happened, but she would have a right to get the money from the person who really took it. And the point is, the dad did wrong, whether he did it with a bad motive, whether he did it with the motive of older gentleman marries younger woman, gives her all his money rather than his children and grandchildren, I don't know. And there's no record on that, so my guess is as good as Mr. Wilkins and what this court can guess. But he did it, and he didn't have any right to do it. The attorney did testify that when he set up this will and this trust, that the purpose of it was so that the children and grandchildren, in this case my client and her children, would be able to inherit some money. Because keep in mind, this was not a trust where you're a trustee and you get to invest this or run this company or, have the co-trustee sign checks in blank, and therefore it's negligent of a co-trustee not making sure things are done properly. This was where the dad was just to get interest from the principal. And if there was a request or if a need for more money, he had to apply directly to the daughter, which he didn't do. So there was no reason for her to believe that she had any responsibility, but to sit there and wait until he passed away and then she would receive the principal. So I don't see where that argument gets too far. I think that, I don't know what more to say than we said in our briefs. I think I briefed it well. If there's any question.
Any question? Okay, thank you very much.
That's it then. Thanks, sirs.
Thank you. One of the points I do want to make is the fact that the court, in its determination of the damages in this case, pulled a number off of apparently a 706 and said, we add that to the amount that was supposed to go to the daughter. That had nothing at all to do with this case. Number one, there's no evidence to even suggest that a 706 was ever filed, and in fact it wasn't. Apparently one was drafted. But the numbers in the 706 have nothing to do with what's used to fund the trust. The only assets that were funding the trust were the assets coming from the estate. Adding $35,000 off of a 706 is absurd. It's not. It clearly shows that the court didn't understand the nature of the issues with respect to that 706. And I think that's the point too, as well as the long delay. There's a 9-month delay. Judge Perry, dropped this decision on the afternoon. I think I got it at 3:43 on his last day on the court. And I think his send-off celebration was at 4 o'clock. So You know, he tried this thing, and he never, apparently, what I believe he did is he went back and just looked at the motions for summary judgment, because he cites all my law from the summary judgment motion and completely ignores the law that I put in the pretrial memo, and completely ignores the fact that he himself said in the transcript that he needed to look at that Brent versus Smathers case and determine if it had some implication with the decision he was going to rule. He never even mentions the case. So in effect, what I think he did is he did not remember the testimony. He pulled numbers that were clearly erroneous, and the judgment should be overturned for that reason, because of the delay, because he clearly didn't get the right answer. Thank you, Judge.
Any other questions? Thank you very much. Thank you. Both of you will stand in recess.
Happy holiday, everyone.